Hi everyone, this is Taylor with the Daily Geddon, and today we're going to take a look at S3985, which is the Justice Act of 2020, and it was introduced by Tim Scott from South Carolina. And the Justice Act means the Just and Unifying Solutions to Invigorate Communities Everywhere Act of 2020. A mouthful. Justice. This is the Republicans' response to all of the protesting and all of the riots and all of the Black Lives Matter movements and everything that's going on right now. And this is their way of reforming some law enforcement techniques and some law enforcement practices. And with that, we're going to roll the intro. Title 1 of this bill is titled Law Enforcement Reforms, and that's because it's got a lot of stuff under its umbrella. The first part of which is a new reporting requirement for state and local law enforcement agencies. And that reporting requirement has to do with use of force. And they will have to report use of force data when events like serious bodily injury happen, a fatality happens due to use of force, or a firearm is discharged either at or from police officers at an individual, or a police officer is killed. And what's interesting about this last statement, when a police officer is killed, is that they included a very interesting statement saying by an ambush or a calculated attack, as if they're so often happening that we need to include that very specific language in this bill. Now, I'm not saying that that's not happening, but it's very interesting language that lawmakers would put in this bill when they could just stop at if a police officer dies. If state and local law enforcement agencies fail to comply with this annual report, and it is an annual report, they will lose 20% for the first fiscal year that they do not comply. They will lose 20% of their retention money that they receive from the federal government. And then on top of that, for every subsequent fiscal year after that, they will lose 25%. So that's a total 25%, not additive. So for the second fiscal year, they'll lose 25%. For the third fiscal year, they'll lose 25%, and so on. The last thing about the use of force data collection is that this information will be 100% available to the public in an online form. That is something really nice to see, that we're moving actually towards more transparency than we are in our current state. The next part of Title I has to deal with no-knock warrants, and it requires that all state and local law enforcement agencies report all no-knock warrants that are issued, as long as it's not going to jeopardize an investigation. And if you don't know, a no-knock warrant is a warrant that's issued in order to keep officers safe when going to some type of situation. Say that knocking on the door would alert somebody that either evidence will be destroyed or will put the cop's life in danger. That's why a no-knock warrant is being issued, or would ever be issued. Title I also deals with incentivizing banning chokeholds, and it goes after funding for state and local law enforcement agencies that don't have a policy in place about prohibiting chokeholds after a certain amount of time. Now, they will only prohibit chokeholds if use of deadly force is not authorized. If use of deadly force is authorized, which I couldn't find anywhere in the bill what that means, authorizing the use of deadly force, then you can go ahead and choke somebody out. To me, that means if the use of deadly force is authorized, you are going to choke somebody out intending to kill them. Interesting way of putting things, but that's the way I read the bill. The next part of Title I has to deal with falsifying police reports, and it slaps up to a 20-year sentence and a fine on officers that are accused and found guilty of falsifying police reports. Now, it's not in the bill, but I did find it interesting. On the Department of Justice's website, under their misconduct statute, they actually have definitions of what misconduct is. And first of all, 3 things have to be present in order to be considered misconduct. And that 1, the police officer had to have deprived a victim of their own constitutional rights. 2, the police officer had to be acting willfully. And 3, the police officer had to be acting under the color of law. Now, if those three things are present and the police officer threatened or actually used a deadly weapon or even hurt the victim and caused bodily injury, then that is a felony, and they will go to prison. Now, I do find it interesting they continue on at the very bottom of this statement to say that mistake, fear, misperception, or poor judgment are not excusable to be willful acts. So if those things are present, they cannot be considered willful acts. That's a massive gray area in my opinion. Title II of this bill actually deals with body-worn cameras, and there's a huge problem in this bill, actually 2 huge problems with this part, is that The first one, it's going to push the policy making for body-worn cameras onto state and local law enforcement agencies and onto the communities. And that is a problem, a massive problem. Make a blanket statement, federal law. All police officers have to wear body-worn cameras. That's for the benefit of both sides. People that are being arrested would have no dispute as to whether or not their actions were wrong, and people that are doing the arresting would have no dispute that their actions were right and that they handled the arrest correctly. And all of this, a lot of it, not all of it, would go away. Now, the second and probably the worst part about this is that they're going to leave the enforcement of those policies that they created, that local law enforcement created, they're going to leave the enforcement up to the local law enforcement agency as well. So the people that made the rules are going to have to enforce them. And that, time and time again, is a huge source of corruption. I'm not saying that's going to happen 100% in a perfect world. Obviously, everyone's amazing and nobody ever gets arrested. But if you give people the power to make their own rules and then enforce those rules, there's no way the situation will get better. Title 3 of this bill has to deal with law enforcement record retention. And what that means is that any misconduct brought up against a police officer or any criminal charges against a police officer have to be retained for a minimum of 30 years. Now, if those charges were overturned in appeals court, they no longer have to keep them because they're no longer applicable to that police officer. Now, if there are certain misconducts or any criminal charges against the police officer, they go into a huge database, which any other law enforcement agency that's going to hire those people will have to look into that database for any new hires. That's not just internal hires. Any new hires, they'll search this database, they'll find their name, and if they have misconduct brought up against them, they have to review it and see if they want to hire those people. Now, that doesn't mean that they do not have to turn those people away because there was misconduct. They can still hire them even though there was some type of misconduct on their record. Title 4 of this bill is entitled Justice for the Victims of Lynching, and it's a huge enumerated list of all of the findings that the Senate has of what's wrong with lynching and the prevalence in American history and the way it was used. And it was used to intimidate certain racial groups away from certain areas, or honestly just to flat out hurt them or murder them or get rid of them. And there's a huge list. We're not going to go through all of it, but essentially the last and most important bullet point of this is it's time to put a actual crime and an actual sentence to the crime of lynching. Now you might be saying it's murder, it's already a crime. I agree with you, but this is more a symbolic gesture of actually saying lynching is a crime, and this is the sentence. Title 5 establishes the Commission on the Social Status of Black Men and Boys, and I read through it and it requires all of this huge reporting on the social status of black men and boys, and I thought that it was extremely sexist, honestly, and I shouldn't spend a lot of time on it because it does nothing for women of color. What about the social status of women of color? They're also marginalized, and I didn't think that it was very fair to give it a lot of time, so we're just gonna move on. Title 6 of this bill is all about alternatives to the use of force, and it's going to require the Attorney General get with labor organizations as well as professional law enforcement organizations and mental health organizations and come up with a curriculum to train officers on de-escalation and use of non-force tactics. It's also going to make sure that police officers are trained in ways to intervene if another police officer is using too much force. That's a completely separate curriculum and completely separate class that police officers are going to have to take. It also gives the Attorney General the power to certify schools, private schools, that police officers can go to. So it's going to create an entire business of educating police officers on non-lethal force and ways to de-escalate situations. What's interesting is that this title never actually says that these trainings are required, but they're going to incentivize them by giving states money to pay for that testing. I hope that it's more money than the actual testing will cost. There's no real way to know that because there's no real incentive to do anything extra if it's not a requirement. Now we're going to skip around a bit and we're going to go to titles 8 and 10 before we get to titles 7 and 9, because 7 and 9 are kind of grouped together and they're super important to this piece of legislation. So with that, title 8 is about law enforcement new hires and training. And with new hires, law enforcement agencies are going to have to look at the community at which they serve, assess the ethnic background of that community, and then hire based on that assessment. So if a community is predominantly black, a law enforcement agency will have to have predominantly black cops. Now with the training part of this section, the director of the National Museum of African American History and Culture is going to have to maintain a website that tells people how to go about the best practices for reconciliation, as well as have the history of racism throughout American culture. Now, I use the word training, but the bill actually uses the word education, and that's because that's what it is. It's not a training. The police officer is not going to be required to take any kind of classes. It's just a resource for police officers to go out and learn about the history of racism and best practices for reconciliation. Lastly, Title 10 closes a loophole that was being used to get away with sexual misconduct in law enforcement. And that loophole was that a law enforcement officer was claiming that the person that they were arresting had given them consent to have sex with them or do some kind of sexual act. And this title would prohibit that completely. Whether you were given consent or not, you cannot have sex or do any kind of sexual act with the person that you're arresting 100% of the time, all the time. And with that, we're actually going to lead into the pivot and talk about Titles 7 and 9. Thank you. Title 7, it establishes the National Criminal Justice Commission, which is a commission that's going to do a top-to-bottom guidance to the state, local, and federal government on how we're going to reform law enforcement. And the last time this was done, the bill finds, was in 1965, and it took 18 months. And that's exactly how long this commission is going to have to come up with some kind of opinion on how we need to reform law enforcement. Now, the commission is going to be made up of 12 different people, 14 if you count the 2 chairs that are going to select the other 12. The first chairperson is selected by the president, and the second chairperson is selected by the leader of the House and leader of the Senate of the opposite political party from the president. Those 2 chair people will then pick 6 people each based upon a certain list of criteria listed out in the bill, most of it having to do with criminal justice. And there are certain stipulations on these picks, 2 of which have to be from tribal law enforcement, 1 for each chairperson, and then each chairperson will also have to pick 2 people that are directly from federal, state, or local law enforcement. That way they get that input from an actual law enforcement officer. Title 9 of this bill lines out a couple of the responsibilities of this commission, and the first of which it lists out is to come up with best practices to encourage equitable justice, community trust, and law enforcement officer safety. The next responsibility it lists out is to come up with a best practice for due process for police officers that are charged with misconduct. This commission will also have to develop best practices for hiring, firing, suspending, disciplining law enforcement officers, as well as best practices for transparency and optimal administration of law enforcement. There are a couple of miscellaneous things in Title IX, like the establishment of use of force boards that will allow communities to get involved with reviewing use of force incidents in law enforcement. Also, it will have a study conducted to educate police officers on things like mental health, homelessness, and addiction. It also has provisions to make sure that the DOJ is a little bit more transparent and distributes the money a lot more accurately and a lot more efficiently. First of all, there was good and bad with this bill. Starting with the good stuff, I like the way this bill goes after law enforcement funding. It doesn't necessarily say we're going to take everything apart. We're just going to say, if we're going to make these new requirements, and if you don't meet them, we're going to take your funding. I like that approach to things. And it's not like we're going to take every dollar that you have. We're just going to take enough to where it's a deterrent. It's not like we're going to cripple you, dismantle you, and take you down. It's more of a, if you don't do this requirement, we will take enough to hurt you so that you will get on board, hopefully. And hopefully there'll be enough deterrent in the beginning when police officers hear about it or law enforcement hears about it, or that they will meet this new requirement. Now, another good thing that I liked was that they were training to intervene. And what I mean by that is when they're going to train certain cops, or they're going to train all cops to intervene when another cop is using excessive force. And really focusing on that, I think would be go miles in police officer and law enforcement training, without a doubt. That would be a huge deal. I'm not going to claim to be some kind of expert, but I doubt that they train that way now. But the bill requiring that at a federal level is extremely good. Another good thing I liked about this bill was the establishment of use of force boards and its attempts to bring in the community in reviewing police force actions, because I feel like there's a lot of stress out there with people feeling like they don't have enough of a voice in how police officers handled a certain situation. The last thing I liked about this bill was the acknowledgement of comprehensive change, that there's a need for a top to bottom reform. That's a really good thing. Now, People aren't going to like it because it's going to take a really long time, and 18 months is a very long time. But when you're talking about something changing something this large, this big, with this many problems forever, hopefully, you really need to do all of the legwork that is possible in order to make it better for people 20, 30, 50, forever years down the line, and hopefully come up with a system that does some really good stuff. Now for some of the not so good stuff. And the first one is the title of their No-Knock Warrant Act. Referencing Breonna Taylor in your No-Knock Warrant Act is extremely insulting when, first of all, you're not really doing anything about no-knock warrants. You're just having people report on them. You're not restricting them. You're not doing anything about it. You're just having reports on them. And the second thing is, it really wouldn't have saved her life. And the way that your legislation is laid out really would not have done anything for her. She still would have been in the same problem that she was, because those officers still would have been at that same place for that same reason, doing whatever they were doing. And it really wouldn't do anything the way you've laid it out. And I honestly think that it's truly insulting to even put her name on the head of that act, on the head of that title, and it probably should be taken off. Secondly, I think that their chokehold legislation is not nearly strong enough. First of all, it's almost nonsensical in saying that when authorized to use lethal force, you can use a chokehold. That makes no sense to me. If you're authorized to use lethal force, why are you not shooting at somebody? Why would you try to run up and choke somebody out and kill them? What does that even mean? When are you authorized to use lethal force, first of all? And why would you want to run up and choke somebody out with the intent to kill them? It just makes no sense in my mind. Secondly, if you're going to use a chokehold and you already can get in the position to do a chokehold, I feel like you were able to take someone down or arrest them in another non-lethal way. Tase them. Do something like that. That's non-lethal. I know I can't say it's 100% not lethal, because I'm sure people with pacemakers, it'll affect that, things like that, and you can ping me for that. But for the most part, it's non-lethal. If you can run up and choke somebody out, there is definitely another way to take that person down without using some type of position or anything to block an airway. Thirdly, I don't think that there were enough training changes. There wasn't enough emphasis on training. There was an emphasis on having education out there, but it didn't seem like there were a lot of requirements in the training. It was just, if you want to go out there and do it, you can. It's not going to be like, we require you to take all of these classes and acknowledge that these are things that happen and that we need to take care of them. That's all I've got for you today. Thanks for watching. I really appreciate it. I think that this is extremely important. I know it was a little bit longer of a video, but we could be seeing some historical legislation go down right now. We could be changing the history of America and making some real change. And I know you want to see it. I know I want to see it. So make sure, if you're not already, get on Twitter and throw as many comments, as many tweets, as much as you can at your senators and representatives, and make sure that they know that you are listening, that you are watching them. And also make sure to @ the Dailygeddon and let me know exactly what you think, and make sure that I'm tagged on those things to your senators and representatives, because I'd love to see them. Anyways, that's all I've got for you. Have a good one. Thanks, guys.